So, and I guess I'll just cut through here. The point that we came to was that a scheme for the motu model based on land use consents overall and for a number of reasons would be preferable. Many of you will be familiar with the key elements of a regional plan change, so this won't come as any surprise to you. We identified that there would need to be an explanation for the reasons for the plan change introducing a nutrient trading scheme. Of course, there would need to be a description of issues, objectives and policies. Right at the heart of the legal structure of a plan change introducing a nutrient trading scheme along the lines of the motu model would be different forms of activities under the RMA. There would be a class of permitted activities for which consent would not be required. And this would include, for example, those smaller land blocks where the transaction costs around requiring consents to be obtained for discharges to be monitored, etc., wouldn't justify their inclusion in the scheme. So a set of permitted activities. Most of the activities that do result in discharges to ground and thereby to groundwater and ultimately to water bodies would, under the proposal, be covered by controlled activity consents, or they would require under the plan change a controlled activity consent. So landowners would need to apply for the consent, they would be granted that consent, and it would be the conditions of those consent which provides the framework for the operation of the scheme. Activities that weren't subject to or in the respect of which controlled activity consents hadn't been obtained would be non-complying. Now, I'll move briefly to this really important issue of compliance. As you've heard from others, from Hugh, from Susie, Motu looked at compliance very carefully because it was identified early on that unless there were clear signals sent to people involved in the scheme that they needed to comply, the whole system might unravel. So dual objectives for the compliance regime were identified as needing to minimise the need for regulator intervention. But if intervention was required, that it would be fair, it would be firm, and it would send the right messages. We looked at what are likely to be the compliance pressure points for a scheme like this running under the RMA, and here is a list of some of them. At one end, you might get landowners refusing to participate in the scheme at all. There might be failure to provide accurate information. Probably the central compliance pressure point of concern would be the failure to surrender the requisite quantity of discharge allowance units which cover the activities on land in the relevant year. Undoubtedly, there would be others. So we looked at the tools under the Resource Management Act in its current form to address these compliance issues. Here's a table which summarises the main enforcement mechanisms under the RMA as we currently have it. You can see that it ranges from the lower end of infringement notices down through abatement notices, prosecutions and enforcement orders. And each of these tools have their particular peculiarities for who initiates them, what the penalty would be, and some other aspects of them. For a prosecution, which I guess would be the ultimate compliance remedy under the RMA if someone either didn't participate in the scheme or didn't surrender the requisite units. The maximum penalty under the RMA, as I'm sure you know, is $300,000 fine and or 2 years imprisonment. Companies are higher and there's a per day fine for continuing offences as well. Typical illegal discharge consents are much lower than that, however. Typical illegal discharge penalties that the Environment Court is handing down range between $5,000 and $60,000, depending on the seriousness. One of the key issues, however, of concern by relying on the existing tools in the RMA as compliance enforcement mechanisms for this type of scheme would be the need for the regulator to be justifying on a case-by-case basis each individual prosecution for an instance of non-compliance. And this was of concern because it could potentially allow farmers lawyered up with competent barristers or lawyers gaming the system, initiating steps to delay, for it to be very expensive for regional councils to be taking prosecution action, and it creates the potential for impediments to the scheme compared to the situation that would be desirable. And so I've noted there that concerning this central component of the scheme, enforcement under the RMA as we currently have it is likely to be time-consuming, expensive, and the outcome not always certain. We thought that there are basic mechanisms for enforcement under the RMA, but as I said, the RMA powers as we currently have it are somewhat of a blunt tool. I'm going to skip over variation 5 for a moment because we're a little bit short for time, but I'd like to proceed then to where we looked, given where we had got to in relation to the limitations for the RMA in its current form, which is another compliance model, the New Zealand Greenhouse Gas Emissions Trading Scheme compliance provisions. These are provided for and a part of the Climate Change Response Act, and under the ETS there are very specific tailor-made legislative compliance tools available to the regulator. They involve, for example, graded penalties depending on whether it's a first, second or subsequent offence, statutory recognition that there are some compliance issues that are inadvertent, but really importantly, power for the regulator after having given notice of non-compliance to recover as a debt the shortfall in surrendered New Zealand units, which is the discharge units under the ETS, with set penalties and interest. So basically the regulator would not need to go to the court, justify and argue on a case-by-case basis remedies for non-compliance. They can obtain or recover as a debt to the Crown the specific shortfall and allowances together with penalties which are set in advance and interest. Where does that get us to? Our conclusions, and this is trying to bring together 4 years of legal work into a very short time, but our conclusions are that yes, under the RMA in its current form, it's possible to implement a nutrient trading scheme, largely along the lines of the Motu model. It would be necessary to get a standard set of conditions in place. It would be necessary to consult widely, and if prosecutions were necessary, there would have to be careful briefing of the court to get the right messages sent. However, there would be significant advantages from having a tailor-made legislative regime, particularly in the enforcement area. And that's a message that I'd like to leave you with, and for officials from the government who are here to consider quite carefully whether there are benefits that could be achieved from a tailor-made legislative solution to support the kind of regime that Motu is looking at. I'll leave it there. Okay. Shall we have questions now or come back to that later?
No, got a 5 minute question.